Hello, everybody. Welcome back to SEC Roundup. I'm Nick Morgan, the co-founder of ICAN, Investor Choice Advocates Network, and the host of today's episode. Super pleased to welcome our guests today, both partners in the Philadelphia office of Duane Morris, Mary Hansen, who is a former assistant director at the SEC. Mary, thank you for joining.
Glad to be here.
And her partner at Duane Morris, Mike Rinaldi, who was formerly a senior trial counsel at the SEC and at the U.S. Attorney's Office in Philadelphia, now also with Duane Morris. Mike, thank you for joining.
Thank you for having us.
So the reason we're talking is because you both filed a complaint on behalf of your clients in the District of Columbia Federal Court. And it is, I guess, of a piece of a pattern that we're seeing, which is more litigation, affirmative litigation against the SEC involving a variety of issues, but in your case in particular, the procedures that the SEC uses to pursue individuals. So I'll turn to either one of you first to sort of just give us the background on the case.
No, you can go.
But
Go ahead.
in a nutshell, you represent a father-son duo in the investment advisor space who have a sort of long-running dispute with the SEC. So, Mary, it looks like you might be taking the lead, and you could just give us some background on the case.
Yeah, so just some background. So our clients, like you said, are father and son. They got into some confrontation with the SEC a couple of years ago. They were investigated for certain conduct. Importantly, not involving any investor harm. There has never been sort of any allegation that any investor lost money, was defrauded, or anything like that. And the investigation took almost a year and a half. They tried to settle it prior to the SEC litigating. They couldn't settle. So the SEC filed a federal complaint. They then went through discovery. And somewhere in the midst of discovery, the SEC said, you know what, let's settle this. And the offer was that they each pay a $25,000 fine, which compared to the legal bills that they had racked up over the course of 2 years was a very small percentage. And so, they decided to settle. What they didn't fully appreciate was that after they settled, the SEC would go in to their in-house administrative proceedings and ask for lifetime bars, industry bars, and that it was basically a foregone conclusion that the staff would get those bars, right? They knew that it was a possibility, but they thought, well, it's an in-house court. We'll still get a hearing. We'll still get our day in court, so to speak. And, they felt very strongly that they had good arguments, that it wasn't in the quote unquote public interest for them to be barred, maybe suspended, right? But they never sort of thought that it would be a foregone conclusion, overdone with, you're out of the industry. And interestingly, it's a father-son. So we have on the father's side, someone who's really close to retirement, who just wants a couple of years, right, to get his affairs in order, to make sort of the last money, right, that he's going to use for the rest of his life. And then on the other end of the spectrum, the son is a young guy. He's got a whole career in front of him, right? And so not only does he have to deal with the fact that he settled with the SEC, which is never good, but if he's going to be barred from the financial industry, that has all sorts of other collateral consequences for someone that has, 40, 50 years left of a career to deal with. And so, they, after the SEC moved for the summary disposition, of course, they did challenge it. And for the last, 18 months, the staff has just been sitting on, or that the commission has just been sitting on the summary disposition. And our clients literally wake up every morning thinking, is this the day? Are we going to be out of business?
Right.
It's terrible. Absolutely terrible. For conduct that no one has ever suggested resulted in any investor harm.
And then as to this SEC proceeding, every way you could possibly make it procedurally unfair, they've done. Right.
Right.
So there's no jury trial, right? There's no due process as you would find in an Article 3 court. There's no independent judge. Rather, the judge here is the SEC, meaning the same SEC that authorized the prosecution against these guys in the first place. And even though federal law requires a hearing before SEC action, the SEC through regulation has said, well, we're going to disregard that and allow the staff to file a motion for summary disposition. So they don't even get to have their day in fake court, let alone real court.
Right.
I mean, that's literally what's going on. And I just think about this, my wife's a nurse, would never marry a lawyer, no offense to lawyers, but you try to explain this to your non-lawyer friends, they think you're joking, right? How could that possibly be the case? And remember, the staff, and some of your viewers may not realize this, but the staff has had repeated ex parte communications with the commission through the action memo process, which you're not going to have access to. You don't know what was said. At a minimum that the SEC looked at those memoranda and decided to institute charges against your client. And that's supposedly your fair and impartial decider of fact.
Right.
Makes no sense.
And Mike, picking up on that point, you're describing the administrative court, the in-house, to be charitable, the in-house process for these things. And your clients have the somewhat unique position of already having gone through the federal court process, where the SEC sought injunctive relief. I take it from your description that the SEC in that federal court proceeding never requested injunctive relief that would have acted as an industry bar.
Exactly.
But now, they pop up again with this follow-on administrative proceeding with all of the procedural shortcomings you just described and ask for this relief in a summary disposition.
Right.
Well, and then there's two additional problems. First of all, when all you have is a hammer, everything looks like a nail, right? So even though Mary is 100% correct in the grand scheme of things, this was non-scienter, no investor harm, etc., right? And so the result is still likely to be a lifetime bar, right? Doesn't matter.
Yeah.
In terms of success, it's like the Harlem Globetrotters and the Washington Generals,
Right.
You know what the conclusion is going to be, and we lay that out in our complaint that these things routinely result in lifetime bars or something along those lines.
Right. So actually, let me turn to that, Mike. Oh, sorry, Mary, I didn't mean to interrupt.
No, I was just going to say, until recently, there has been virtually no hearings actually granted after the staff files a summary disposition based on either a criminal conviction, guilty plea, and or just a settlement, a federal court settlement. So it's you could take any one of the staff's summary disposition motions and it's basically cut and paste, right? The person settled, so they get kicked out. That's it. Sort of, it's over.
Yeah. When I was on the staff and Mary likely has the same experience. I mean, it was the stupidest legal writing you ever did. Right. It was, it's so easy, even a caveman could do this, right? I mean, that's what happens. And there's, again, no hearing. This gets put in, and then you're in the position of arguing against the SEC's colleagues down the hall as to why your case should be the one case where the result isn't a bar. And that's just not the way, most people think the justice system ought to work.
Yeah.
And then the SEC, it's in the public interest that these guys be taken out of the industry. But at the same time, they investigated them for 2 years. They litigated with them for 2 years. They settled with them. It was 7 months later that they even filed the follow-on proceeding. And then it's been stayed now for another year. So, I mean, if these guys are so, such a danger to the investing public, where's the sense of urgency? They almost defeat their own in the public interest.
Right. You would think you would ask the federal district judge that you were in front of, like, hey, these guys are a danger. Like, you got to do something about that. Instead of just having this Mickey Mouse obey the law injunction, maybe we ought to protect the investing public. But now, years after the fact, while they've been serving investment advisory clients for years, and those people are happy with them, right? The SEC may or may not decide that it's, quote, in the public interest to take them out of the industry for conduct that quite literally happened a decade ago.
Yeah.
I mean, it's like Alice in Wonderland.
So I do want to, I agree, it is like Alice in Wonderland. And I do want to get to the complaint you just filed, because so you've described there's an unfair process. And even as to that unfair process, your clients are stuck in limbo. That process doesn't even get resolved, and which is, I assume, an untenable position for this father and son duo professionally, to have this sort of hammer hanging over their head. And then recently, last December, you decided to take action on behalf of the client. So tell me what you did and sort of outline for us the claims that you presented in that action.
So as Mary and I say in our LinkedIn post, sometimes when you're dealing with the SEC, the best defense is a good offense. So we sued the SEC. And we said all of this is improper under the US Constitution, right? It lacks due process, it lacks a jury trial right, it lacks an independent judge, and also statutory issues, right? The Administrative Procedures Act and the relevant federal securities law provide for a hearing, and the SEC has decided, well, we're not going to do a hearing because we're going to promulgate a regulation that goes directly against the statute. And when you put all of that up against some recent Supreme Court decisions, Jarkissi is one, but Loper Bright is another, it just doesn't stand, right? And so we understand that there's a body of case law out there that's old and dated and does not comply with more recent SEC Supreme Court dictates. And that's what we're teeing up for the court, that when you look at those recent Supreme Court decisions, the natural extension is this kind of regime cannot be allowed to continue.
And so you filed your complaint in federal court asserting those claims, and the SEC has not yet responded, but will in due course.
Yeah, I mean, they get about 3 months to do it under the federal rules. We'll wait for their response. Look, I mean, I think also a very significant event happened earlier this week, which is, there's a new sheriff in town. And look, I think the last 4 years at the SEC have been a story of misplaced priorities. I mean, everyone on this call has worked at the SEC before. In theory, they can do good work, right? They've got an important mission, but they have been sidetracked with things that are at best ancillary to that core mission. And it's when they do things like this, they forget why they exist, and instead, they deal with esoteric issues, or they try to do regulation by enforcement or other sorts of things. That's when they get off the track. And this is a prime example. Look at these fellows who have been faithfully serving clients, and if the SEC's role is to protect the investing public. And that is what the test is. It is very hard to conclude that 10 years on, our clients ought to be barred without even the opportunity to say one word in this in-house court.
Right.
And I think the aggressive sort of prosecution that we've seen over the last 4 years, and even before that, right? Because this whole in-house court issue has been percolating. But I think it finally hit a point where everybody's paying attention now, right? And all eyes are on the SEC like never before. And look, I think people sort of realize it's almost like a wake-up call, like, oh my God, yeah, the SEC has been doing this to people for years now. It's time to stop, right? Like it's that we got the Supreme Court, great Supreme Court decisions, and this really is just a natural extension. I mean, if there's any penalty, and I think we use this, right? The death penalty, a career death penalty, certainly is entitled to more than what is the summary disposition that's routinely used.
Right.
And you have to remember how we got here. I mean, if you go back to pre-2010, right, the use of these administrative proceedings were very narrow, right? And what the SEC did was it expanded the scope of them, essentially as a way to have a more friendly audience for larger fraud-based claims, including in some cases insider trading cases, right? They would try to do everything through them, and that's what really focused people's attention on it, right? Is that essentially the enforcement staff was trying to get around meeting the burden that they would be held to in federal court. And here in our case, it's not a hypothetical. The SEC was in fact in federal court. And you have to think back to yourself, if this question was posed to the federal district judge, whether a case so serious, I'm using that sarcastically, that what it resulted in was a $25,000 fine for each of these men, that ought to result also in a lifetime industry bar. It's very hard to reach that conclusion.
Right. Well, there's probably a reason they didn't pose that question to the federal court judge.
Well,
maybe we'll
And they
leave it
never
there.
do.
Yeah. We'll leave it there. We'll check back in on your case. Wish you luck as you face whatever the SEC's response is going to be. And as you say, as of yesterday, we have a new acting commissioner, chair of the SEC. Maybe you'll get more traction on informal channels outside the court proceedings. So, Mary, Mike, thank you so much for joining us. For everybody else, please join us for the next SEC Roundup. And in the meantime, if you want more information about ICAN, you go to icanlaw.org. Thanks, and we'll see you next time.
Thanks,
Thank you.
Nick.